Morning, everyone. My name is Glenn. This is Legally Speaking. I'm an attorney with Woods and Bates, Lincoln, Illinois. And today I want to talk a little bit about estate planning for blended families. So when I talk about blended families, it can mean a lot of things. If there are folks that get married and they may have children from a prior relationship, that would be a blended family. If it's a second marriage, it could be a blended family. If there are, relatives or things that we consider to be relatives that aren't by marriage or biological or adopted, then it brings in maybe a little bit more complexity when we're talking about estate planning that's necessary to accomplish the client's goals. So taking the Brady Bunch example, if you will, each spouse came to the marriage and they each had children prior marriage. So if they wanted to do some estate planning and potentially provide for the other spouse's biological children, they would need to specifically outline that in some estate planning documents. The state statutes are not going to provide for that automatic. State statutes are geared toward the spouse, biological or adopted children. They're not geared toward blended families. In a second marriage, perhaps, maybe one spouse wants to protect the assets for the benefit of the surviving spouse, but they also want them to be available for their children in the event that their spouse gets remarried after they die. We can use trusts and things to make that happen. So it's not an insurmountable plan that needs to happen, but it is something that may add a little bit of complexity just out of necessity. And those are things that we would be happy to discuss with you. Our telephone number is 217-735-1234. We look forward to hearing from you. Thank you.